Caucus room. If you haven't taken a moment to read the chart on the back of the wall about the historic significance of this room, you should. It is amazing what has happened here, and I couldn't do it justice trying to recall, but I do believe John F. Kennedy announced for president here, as did Robert Kennedy, and this was also the site of the congressional senatorial hearing on the sinking of the Titanic and many other things. So please, if you're a student of history, take a moment to read the history of this room. And speaking of history, this year marks the 100th year that Major League Baseball has been exempt from the Sherman Antitrust Act as a result of the Supreme Court decision in the 1922 case Federal Baseball Club versus the National League. Over and over again, the Supreme Court has said it is up to Congress to decide the role of Major League Baseball when it comes to antitrust exemptions. I happen to think at this moment in time we should be revisiting this issue. This Major League Baseball lockout started on December the 21st and has resulted in cancellation of the beginning games of the baseball season. I think this is the appropriate time for us to ask about the status of this industry, baseball industry, under the law and the antitrust exemption. We're going to be preparing a hearing on that subject in the very near future. My advice to Major League Baseball owners and players: think of the fans, do something for them. For goodness sakes, this lockout is an insult to a lot of loyal fans who spend an awful lot of hard-earned dollars following their teams. It's time to play ball. So let's go to—
Mr. Chairman?
Yes.
Could I speak to that for 12 seconds?
Sure, Senator from Utah.
I have a bill to do just that. The chairman raises legitimate concerns. I do think we should revisit it, and I think we should overturn that case. I've got a bill that does that. I'd love to work with you on it.
I think this might be bipartisan, as baseball is, so let's look forward to that possibility. So we have 9 nominees on the agenda today, all of whom are eligible for a vote. I'm going to focus my opening remarks on one of them, Nina Morrison, in the Eastern District of New York, before turning to Senator Grassley. We'll proceed to a vote on the nominees in the order that they're listed. As we've done in previous markups, I ask members to wait until each nominee is called if they wish to make a comment on any specific nominee. Today we're going to vote on Nina Morrison. At Ms. Morrison's hearing, members of this committee made many claims about her that I think need to be addressed. Ms. Morrison has spent nearly 20 years litigating with the Innocence Project, where she's pursued, I think, an honorable, noble goal of exonerating wrongfully imprisoned individuals, largely through the use of DNA evidence. Approximately 30 of Ms. Morrison's clients in more than 10 different states have been freed from prison or death row. Clearly, she's someone who understands there are catastrophic consequences, both for the wrongly accused and for crime survivors when the wrong person is convicted. And so she's voiced strong support for conviction integrity, which the units review potential wrongful convictions and consulted with prosecutors on how to set up these units. Thanks to Nina Morrison, innocent people have been freed from prison, crime survivors have received justice, and actual perpetrators of violent crime have been identified and taken off the streets. Yet, incredibly, members of this committee suggested that Ms. Morrison is somehow soft on crime and is to blame for, quote, skyrocketing crime rates. Let me emphasize that again. Members of this committee argued that releasing people from prison who did not actually commit any crime is dangerous for society and leads to, as they said, innocent people being killed, close quote. That kind of fear-mongering is unacceptable. It is not somehow antithetical to the rule of law for an attorney to represent criminal defendants. The founders and Supreme Court have been clear on this. There is a Sixth Amendment right to counsel, and this right means that criminal defendants deserve zealous advocacy. The cause of justice is served when there is effective and competent counsel at both tables in the courtroom. During the Trump administration, when this committee considered Trump nominees who represented criminal defendants, my Republican colleagues didn't argue that they were somehow a danger to society. One final note. I requested that we all be very careful about what we post on our Twitter pages and other places about nominees and to avoid inflammatory and disrespectful commentary. I made this request because one of our nominees received a threat of physical violence that directly referenced a social media post made by a member of this committee. We live in a dangerous time. These people are offering themselves in public service. Let's at least be respectful of that reality, that we should be protective of them in the process. After Ms. Morrison's hearing, a member of this committee posted a tweet linking her work to policies that, quote, result in more innocent people being murdered. That is the exact quote from the tweet. This kind of rhetoric is not just false and inflammatory, it's dangerous. Now turn to Senator Grassley. I want to thank my colleague. I would like to perhaps disagree with him in 2 or 3 things before we proceed. American Rescue Plan, remember that one? Do you remember how many votes came from the other side of the aisle for the American Rescue Plan?
None.
None. And so all of the money that went to the state and local governments to deal with the problems they faced, COVID-19 or anything related to the downturn in the economy, came from a plan supported by one party and opposed by the other party. And now to argue that we were not generous enough to state and local governments when we voted for it and the other party voted against it, I think is a troubling conclusion. I would also say that for many, including my hometown and other cities, the notion that they were given some financial help in one area freed up funds for other areas. And they establish, as we hope they will, the priorities, and I certainly believe law enforcement is one of the highest priorities. So I will concede the fact that there could have been more specific language about helping law enforcement, but the American Rescue Plan helped cities and states, and they were able to come up with resources that otherwise it might not have been available for law enforcement. Secondly, I'm going to try to make this very brief because it's a complicated issue, but when it comes to the Sentencing Commission and Justice Jackson, Judge Jackson has been approved by the Senate 3 different occasions with bipartisan support. She has made complete disclosure, meeting and exceeding past nominees in each of these Senate efforts. The most recent was just last year. Judge Jackson's public record includes 578 written opinions she's authored as a judge. She has disclosed over 12,000 pages of detailed records of proceedings from the Sentencing Commission where she served as a member. The Sentencing Commission is not an agency of the legislative branch nor the executive branch of our government. It is an agency of the judicial branch. It is one of the most transparent agencies in federal government. Though it is bipartisan in its composition, 97% of the Commission's decisions when she served on it were unanimous. In fact, you'll find her many times in concert and partnership with Judge Pryor, who is considered to be a well-recognized conservative. Apparently, that did not preclude Judge Jackson from joining him on many of these decisions. We had a bipartisan call yesterday to the Sentencing Commission about this discovery issue. The Sentencing Commission staff confirmed that the vast majority of relevant materials from her tenure on the Commission are already in the public domain, including minutes, reports, public comments, amendments, and similar materials. The Commission staff made it clear that the vast majority of the minimal non-public material that might exist are documents generated by career staff and provided to all commissioners, not just to her. Finally, Commission staff made it clear that a request of Sentencing Commission documents would raise significant separation of powers concerns, as the Sentencing Commission, as I mentioned, is part of the judicial branch. This is a door that's never been opened before because there's very little, if anything, behind it. This transparent disclosure of 12,000 pages will certainly give us access to any reasoning and any record vote taken by Judge Jackson. So I have to raise a question as to why this is considered to be an integral part of the investigation.